Hello friends, today I am with advocate Nikhil Mengde sir, and we will be talking on how is the scope in POSH law. Nikhil sir has done his LLB from Mumbai. He has done his LLM from Sydney Law School. He is practicing since last 15 years. He was consultant to various multinational companies. He is practicing for 6 years in the criminal law, and since last 9 years he is practicing in the POSH law, that is prevention of sexual harassment at workplace. So we'll start our interaction with Nikhil sir. Nikhil sir, first of all, thank you. You have given the time for this particular interview.
Thank you, sir. Thank you.
Sir, we would like to know that how did you get inclined to start your practice in POSH?
So what happened is before the legislation was enacted, I was working with this one company whose chairperson was heading the women's wing with the Indian Merchant Chambers.
Okay.
And generally, whenever a new act is, in the process of being promulgated, they invite suggestions. So at that time, they had sent the draft to this chairperson, and because I was the legal person the person heading the legal team, she sent it to me to ask for my opinions what it is. So I had given some few suggestions here and there. Not many of them got incorporated, but that is when I came to know that this act is coming into force, and I looked further, and I learned that this was already there in the Western countries and many other societies. Also, it is not that only when this act came into, when it was brought into force, that this law. Before that also the Vishaka guidelines were there. But then they were more of a guideline, so did not have a binding effect. But yes, to answer your question, it was that lucky moment when I came across this legislation, and I thought it has immense potential, to build a practice.
That means you have been, I would say, one of the contributories giving your suggestions in the formulation of this law.
Well, contributory, certainly I gave my contributions, but not many of them got it. So, yes, you would be right in that.
Now, sir, how can this POSH itself be explored as an independent area of practice by lawyers?
Well, to answer that, it is not a separate legislation as such which requires a different specific practice, and the answer lies in the nomenclature or the articulation which they have used with the act is called Prevention of Sexual Harassment Against Women, Prevention, Prohibition and Redressal Act. So there are three aspects which are which this law is trying to achieve. First is that of prevention of sexual harassment. Under prevention, there are certain initiatives which the employers have to take. That they have to sensitize, they have to conduct trainings, they have to educate the workforce of what is sexual harassment, what are the different forms of sexual harassment, how one should, if someone feels that he or she, and mainly this only covers women, so but it can be gender neutral as well. So, if one feels that he or she is being a victim, then what are the procedures that has to be adopted? So, that education, that comes under the prevention aspect. Then there is prohibition, where a specific policy has to be, emulated within the organization. That has to be publicized. Everybody has to be told each and every, because since it's a new concept altogether, although this act came into force almost 9 years ago, still people are trying to learn what it is, and the implementation unfortunately has not been so. So that policy has to be told to each and every employee. Then the third aspect is that of redressal. So in spite of taking these steps, if unfortunately there are any complaints, then what is the manner in which those complaints have to be redressed? It is an internal inquiry which has to be conducted. So internal complaints committee, or what is now to be called as internal committee, IC, is to be formed by every employer. What is the constitution of that? So the constitution, it has to be more than 50% members have to be women, and there has to be one external member in that. So that external member, if you read the rules, it says that any person who is acquainted with labor, civil or criminal laws can be external members, which essentially would mean lawyers. So lawyers can empanel themselves as external members. So under the redressal, that is the opportunity that a lawyer has. If you are a good orator, then you can conduct trainings, Of course, drafting the policies and overall consulting companies is also one area. So these are the three aspects on which mainly one can develop their practice. But because the implementation has not been so much, I don't see this as the only area of practice a budding lawyer could do. Of course, there are organizations who are doing it. So there is an organization called Comply Karo. There are a few others who are doing an excellent job at it, who provide end-to-end services in this. So one can perhaps sort of associate himself or herself with such organizations to contribute. So that essentially would be the area.
Sir, right now you said that IC has to be there.
Correct.
Now, is there any minimum and maximum limit of how many members should be there in IC?
Right. So there is no maximum limit. So it does not also give the total number of members. It just gives the requirement. So it says that more than 50% of the members have to be women. The chairperson has to be a lady at a senior position in the organization. There has to be one external member. So if you calculate that, and there have to be two members who are preferably associated with cause relating to women and children. So if you calculate that, comes to 4, and therefore I would say minimum is 4, but there is no number given over there.
Okay.
So minimum is 4, and as long as you meet the requirement, it can be whatever.
Oh.
So with many companies, it so happens is that their head office is located in one city, but they either have branch offices or factories. So in such cases, what I advise one can do is, because what the Act is trying to achieve is each and every employee should have an access to this IC.
Correct.
So what you do is you have say 5 to 6 members from the head office and then 2 members from these branch offices.
Okay.
So for example, if the head office is located at Pune, and if there is a factory located at Nagpur and Delhi, then there could be 4 consistent members from Pune. The one at Nagpur would have these 4 and 2 from Nagpur, and the Delhi would have 4 from Pune and 2 from Nagpur.
Okay.
So then there is a access which is also achieved. At the same time, you don't have to set up various
Multiple
different
ICs.
So that is how it would work. So there is no maximum number.
Okay. Sir, you said that 2 members should be there who have to be associated with the cause of women
and children.
Now, this people have to be the employees of the company only, or they are again the external persons?
No, they have to be employees. So only one external member is mandated.
Rest all IC would be employees.
Employees, correct. Rest everyone is employee. Only one, minimum one. You can have 10 as long as. But minimum there has to be one external member. That is to, I suppose the objective would be to, not have any biasness, because the external member would be very neutral. So that is what they are purporting to achieve. But everyone else has to be an employee. So these, and when they say preferably associated with cause of women and children.
Preferably.
So
okay.
It is not a must. So if there is somebody who is working, say, in the CSR department or in the HR department, or is as a curricular activity doing some social cause, then preferably should include them. That is what the says. But it is not a mandate as such.
Okay. And the external member has to be a woman or a man, anything specific, or anybody can be member?
Anybody can be external member. Like I said, as long the chairperson has to be a senior woman employed at a senior position. External member, it doesn't say whether it can be both. It can be man or woman. But it need not necessarily be a lawyer. It can also be a social worker.
Okay.
So that is what it says. As long as you maintain the 50% threshold, the external member can be either a male or a
Okay. Just one concluding question on this IC only. If a woman is a director of a company, can she be the chairman of the IC?
Yes, most certainly she can. But if at all, in fact that goes for any other person. So if at all there is a complaint against a person who is a member of the IC, then that person will have to obviously step down. But if a lady is a director, definitely there is
she can always head
no bar.
The chairman of it.
Yes.
Another thing is, supposing a company is having, it's a group of companies registered in one single premises, which is there normally in Bombay at various big companies. They have only one registered office.
Correct.
In such case, there will be only one IC, or
No. So how it works is there is the definition that that is encapsulated under the Act is that of an employer, and every organization who has 10 or more employees, they fall within the ambit of, and they have to comply with the provisions under the Act. So if there are 5 companies registered at the same address, but if 4 of them have more than 10 employees on their payroll, then they would have to have those, you know. So a registered address is really not a condition.
It's a number of employees.
It is a number of employees that there are on the payroll.
Above 10, IC is compulsory.
Above 10, then IC is compulsory. Now, interestingly, it doesn't say whether 10 or more women or 10 or more men, but it just says more than 10 employees. So
okay. Sir, is there any specific knowledge required for a lawyer to start the practice of litigations or something in this POSH, this area of law?
See, sir, actually the Act is not that vast. Okay, it is just, I think it has some 30 sections and around 15 rules. So perhaps it can be, I mean, one can get acquainted with the Act in not more than 2-3 days. But a knowledge in evidence law definitely would help, because if you are a member who is empaneled on the external committee, and if you are part of conducting the inquiry, then what evidence has to be received, how it has to be received. Now this Act doesn't lay down any procedure. Neither does it say that Evidence Act will apply.
Okay.
It just says that principles of natural justice should be observed while conducting the inquiry. So there is a rule, I suppose it's Rule 7, which lays down the manner of conducting an inquiry. And on this aspect, it only says that the principles of natural justice have to be followed. Now it is a very vast concept, what is the principle of natural justice, but who better than a lawyer to determine what are the principles of natural. So both parties should be heard. If there is some evidence brought, then the other party has to be served. So that knowledge of evidence law or practice and procedure, that definitely comes handy. So yes, if you are wanting to practice, then I would really recommend you should develop your skills on that side of law.
Okay. So I think the basic laws which are governing our evidence or our trial cases.
Correct.
A lawyer who wants, what I'm gathering from you is that if a person has to be a person, first I'll ask you, what is the role of external member in this IC?
Correct. So there is no separate role attributed as such to the external member, but like I said before, I suppose the objective would be that the external member would bring in, eliminate any element of biasness if there is any, because if a senior person is there, or if for whatever reason, if the complaint is against somebody who is a very resourceful employee, then in that case, if all of them were internal, perhaps they may not want to take action against, or if that person against whom the complaint is made is in an influential position, there is a likelihood that the action would be, diluted. So to ensure that that does not happen, the external member is there, that one. But once you, as a lawyer, you obviously contribute in these aspects in terms of maintaining proper records, how meetings are to be conducted. So that skill, I would say, is not an expectation, but something that you can bring on table as part of your role on the committee. But I don't think there is any special expectation from an external member.
Okay. Is there any such kind of a requirement in law that minimum so and so meetings have to be there, or who will draft the rules and regulations of IC?
So IC, one can draft as part of the policy or as to how the the inquiry has to be conducted. Like I said, there is a Rule 7 which gives the manner of conducting the inquiry, but it doesn't whisper any more than saying principles of natural justice have to be followed. It does say about how the complaint, if it is received orally, then it has to be received in writing. It has to be served on the the respondent, as they call it under the Act. Then it gives a time frame. That the inquiry has to be completed within 90 days, so on and so forth. But it does not give smaller final details of every step that has to be followed. So therefore the procedure as such is not given under that. So how the meeting has to be conducted is really a chairperson's call or a unanimous call of the committee. So to quote you a very interesting case, one of the inquiries that I had conducted, the allegation was that certain incidents had taken place in a hotel which was outside the premises. Now we wanted to get the CCTV footage. So what the Act says is that the committee will have all those powers that of a civil court.
Okay.
But you see, this hotel was really owned by, it was a typical South Indian hotel, which was not owned by a person who's very learned or who would understand what's it. So I went there and he said, "Who are you? Are you a police officer?" I said, "No." Then like, "Why should I give this to you?" Then I had to explain him what it is, how I was, otherwise I will have to issue a summons to you, which I don't want to. And then eventually gave me that. But that is the value add of a lawyer.
Okay.
If it was a non-legally trained person, he would perhaps come back saying, simply return a letter to him, saying, okay, he's not giving, now I'm coming back. But he would not realize that there is a special provision that you have powers of a civil court. But we had to document all this, our visit, who went there.
Okay.
So all this was on the go. How that has to be done. So there is no specific list of rules or procedure that has to be followed. Precisely perhaps because the manner in which the inquiry has to be conducted really cannot be, coerced or confined in a set of rules or principles. So yeah, that if that answers your question.
Sir, formation of this IC under the POSH Act, is it made mandatory under any act for the company? Mandatory?
Yes, it is under the Prevention of Sexual Harassment Act that any workplace having 10 or more employees, again with a caveat that it doesn't say 10 or more women employees, it just says 10 or more employees, has to have an internal complaints committee with that particular composition.
Okay.
So it is under section 4, if I am not mistaken, that IC has to be formulated.
Okay.
And in fact, if you don't, then it's a punishable offence.
Okay.
Yes, so the punishment goes to 50,000 for the first offence, and I think it's 25 and then 50, and then it may also lead to revocation of your license. So the shops and establishment.
Who has? I am coming to that only. Who has the authority to go to a company and ask them that if you are having more than 10 employees, have you framed a IC? Who has that authority?
Unfortunately, till date, I don't know of any incident where a enforcement agency has come to check on this compliance. Okay. But I would, so there are 2 or 3 places where this compliance has to be done. One is that you every year have to submit an annual report to the district officer. District officer is defined under the act, but it essentially is generally the collector of the district. And you have to submit a report as to how many complaints were received, what were the outcome of those complaints, and what are the initiatives you have taken. A shops and, at least for the city of Mumbai, I think the shops and establishment inspector would be the correct person. But like I said, that the implementation has not been so much. So at least to my limited knowledge, I haven't heard any incident where an inspector has come and said that there is no, you are required to do this and you have not done this. But it is the shops and establishment. Also, perhaps the, the Women and Child Welfare Ministry, if there are some officers from there, they may come. But where it would really cost an organization, company deal, that if there is an incident and if an employee intends to complain, and if at that time there is no internal complaints committee, because then that private individual will take its own recourse, saying that
directly
this company,
to the collector.
Yes, the district officer. That would be then, looked at in a very bad light. The company would be looked at in a very bad light.
But sir, since we are talking about mainly about companies, of course, this will also include partnerships and everything.
Yes. Organization, like I said, the word that is a workplace or organization.
Any kind of an embargo has been put under the new Companies Act regarding this?
The annual report which you submit has to, I think there is a space where you have to mention your compliance, and precisely the same annual report which you file to the district officer, that also has to be mentioned in the your annual report of the company.
Yeah, because then only somebody can find it properly.
But I don't think that the ROC officers would be empowered to check on the compliance. But like I said, because it has not happened till date, so we'll have to wait and watch which officers really go and check for the compliance. To my knowledge, it would be the shops and establishment officers. Because, and I'll tell you why I'm answering that in that manner, is the consequence of not having is cancellation of your license. Now, which license? It is the shops and establishment license.
Okay.
It is therefore that I feel that it would be the shops and establishment.
Okay. Sir, now what is important is an external member. Now he has to give training to the employer, like employer or IC.
It is not the external member who has to give the training. Anybody can give the training. again, it's always better if a lawyer does your trainings because he comes from the, he will give you a background. So there are certain concepts under this act, like what is a quid pro quo, what is a hostile work environment, which is, would perhaps, a lawyer would understand and explain them far better than a non-legally trained person. But a trainer need not necessarily be a lawyer. So that again is a very good opportunity for budding lawyers if they acquaint themselves with these concepts. And it is 1.5 hour training. Generally, when I do my trainings, I divide them into 3 segments. One is for all the employees, one is for managers, because many a times what happens, sir, is that an employee is likely to go and talk to his manager if there are certain incidents instead of going to the IC directly. So these managers also have to be trained as to what are, how do you identify a complaint, any complaint as a sexual harassment complaint? Because first that has to be there.
Exactly.
This committee which is formed does not have authority to investigate into any and every complaint. It has to be a complaint of sexual harassment. So then there are these filters which I explain them, that you first see whether there was any unwelcome acts, whether there were any advances, whether those advances were sexual in nature, what tenor was there, and then if you, if your answer is whatever positive or negative, then you qualify that and send it to IC.
Okay.
Because it happens many me also. Even if a person goes directly to, like women complain that I am made to sit late in office. Now, as much as it is a very genuine grievance, it is not a complaint of sexual harassment. In fact, to tell you an interesting story, there was also one female employee who was asked to leave early every day, and her team used to sit late.
Okay.
And she filed a complaint with the sexual that I am being discriminated against because all those people are being working hard on a project, but just because I am a girl, I am asked to leave early.
But this she filed the complaint under the POSH.
Yes. Now the IC obviously took, and we did not go any further by saying this. With no stretch of imagination can be said to be a sexual harassment complaint. But now whether or not that is discrimination, I don't know. But there are such kind of interesting experiences also. Yeah. But when it comes to trainings, it is not the external member who is expected to do the training, but generally when I approach companies or my customers or clients, I give it as an entire package. I empanel myself as an external member, and that is something that like I said is a very good area of practice for young lawyers, because you get a one-time empanelment fee. Every time you go for training you get a fee, and if at all unfortunately some incident, then sitting charges for inquiries is again something that you can
Sir, if somebody wants to groom himself for creating these training programs, basically what basic things he should know?
Most certainly the concepts of sexual harassment.
Okay.
So that research is very important. There are the case laws which are there, because see, the purpose of this training is to, number one, educate, but also to clarify misconceptions. The moment these these initiatives or these the requirements under the act are implemented, half the male employees or men would start thinking, oh, now is it okay to go and talk to a girl? Can I say hi? Can I send her WhatsApp? Can I talk to her after office? So those misconceptions have to be cleared. See, the objective is not to punish men or to not have men talking to women. It is to create a hostile work environment for female employees, which unfortunately is not. And when I'm talking about work environment, is not hostile, sorry, congenial work environment. Pardon my language. And in the the organizations which we see, there are it's a very good work environment. But when you go to these factories, cottage industries, over there it is really bad, where generally the supervisors are men and the women are the ones working
employees.
Yeah. So over there they need to be told what is it that you need to do, what you cannot do. So these concepts of sexual harassment are very, very important to understand. Like I said, what is a quid pro quo? What is a position of power? What is a, as they call it, authority matrix? What is unwelcome advance? You see, so that can come only with reading of and there is really good literature on this. Both Indian and international authors have written really good books. So once a person acquaints, then perhaps
he will be
in a far better position to deliver the lectures, because again those training sessions are interactive, because the people, your audience would want to clarify their doubts.
Correct.
So that clarifying the misconception is, I think, the greater objective behind these trainings. And to be able to do that, you need to first understand what are these concepts.
Okay.
So yes, that is what a person would like.
Sir, when a complaint is filed before IC, the opposite person or the complaint against complaint is filed against a person.
Correct.
What kind of an defense he has, one, and can he engage an advocate, number two? This is what I want to.
I would answer number 2 first. So no, the
Okay.
Act specifically says that a legal representative is not allowed in the internal inquiry. So far as the defense is concerned, he has almost all the rights that a person would have in any other trial. Right to cross-examine, right to reply, right to understand what are the allegations or imputations made against him. So those are his rights. But what defense he would have would really depend on the merits or the case. You know, what are the allegations level. Mostly when it comes to, and also what happens is many times, or in fact most of the times, these incidents happen behind the closed doors. So there are no eyewitnesses.
Exactly.
So at that time you have to check what is the subsequent conduct. Because you cannot also discount the possibility of the complaint being filed to seek vendetta.
Correct.
Because a lady or a female employee is a poor performer and she's picked up for that. There are incidents like that, we cannot deny. And the Act provides for that also.
Okay.
So that is one of the things one needs to tell in the training too. In fact, this Act is there to protect you. That if there are any false or malicious allegations, then the same punishment which can be given to a male employee can also be given to such a complainant. So that is also provided under the Act. So if at all somebody feels, a respondent feels that this is a false case, he can in fact tell the committee, you please inquire further into this, and I am saying that this is a malicious complaint.
Okay.
So that is one of the defenses that.
Okay. So even for a false complaint,
yes, there is.
Person can be penalized for that.
Correct.
Also.
Yes. Also, one more aspect is that the Act provides for what is called as a conciliation. What it in fact does is that the prerequisite for initiating an inquiry under Section 11 is that the committee needs to afford an opportunity to the complainant if she desires to reconcile the matter on whatever XYZ terms. To give you an instance, sometimes there are incidents which are not very serious or grave in nature, and the respondent says, yeah, maybe I did XYZ, but it was not my intention, and I am ready to apologize. Then you confront or you talk to the complainant again that this is what he's saying. Are you willing? And it happens in many cases that she says, okay, if he's ready to apologize and not do it, I'm okay to reconcile the matter. So it ends there. Then you don't have to inquire. So he issues her a written apology or whatever. The only thing you cannot ask as part of the conciliation is for monetary settlement. So complainant cannot say you pay me 50,000 rupees and I will reconcile the matter.
Okay.
And fairly so, I mean it's quite self-explanatory why that is there. So all these smaller aspects, it is only one who is well averse with the law. That person can tell the committee or the employees about these things. So that answers.
Sir, what kind of an orders can IC pass if they find somebody guilty of that? Yet yes, he has done something really wrong.
Correct.
What kind of an orders IC can pass?
Most, the most grievous or the toughest order is that of termination. Okay. Because ultimately it cannot order imprisonment. It's ultimately a internal body. So it cannot order that. Monetary compensation. As part of the final order of the inquiry, monetary compensation can be given to the girl. If she has suffered any injury or sustained any monetary losses, if she has stopped coming to office and there is loss of income, then on those grounds, a verbal warning, a written warning. So all those punishments which can be imposed for any other misconduct. Also, the IC can recommend punishments to the employer.
Okay.
So depending on the gravity, it can say, okay, this is very grave, so this is what we recommend to you, you please do that. It cannot directly issue termination letter because he is not in the employment of the IC, he is ultimately in the employment of the employer.
Okay.
So it can recommend saying that, and there has to be a substantiation to that also. The gravity has to be considered, and depending on that, but yes, the most, so to say, strongest punishment is that of termination.
Termination.
What more can one do?
Uh,
Suspension is there, transfer can be done.
Okay.
So all those things.
Sir, you said in this that IC can also give monetary compensation.
Correct.
Now, supposing if that is not, the person is not have paid that monetary compensation, are there any ways and means to recover that? Like in civil suit, we have various things. Here, what is the mechanism?
Honestly, till date, I have not given monetary compensation because fortunately, in none of the inquiries that I have conducted had the victim, suffered any injury or any kind of monetary loss. But I would say it would be enforced like any other decree or award. So she would have to go in, if she is not paying, then either whatever remedies are available under CPC to enforce a award or a decree, or to go to a labor court and file a criminal complaint. I'm sure you're aware that you can file criminal complaints in labor court also under ULP. So that way, but I cannot answer that appropriately yet because I have not come across and I have not ventured into how that would happen. Okay. Perhaps I should do that as part of my next research.
Generally, sir, how much percent this act is used positively and negatively? What is your feeling about it? Like misuse of the act is how much percent?
There are instances of misuse, but I would say it's used more positively, as you put it, or more to achieve the objective with which. Because see, I'll tell you, sir, no woman or girl would unnecessarily do this. It is much more, which is again a very unfortunate thing. It's much more of a shame for her to go out and even complain, let alone whether she's right or wrong. But even to go out and complain, our society will look at her in a different way first. In fact, it is rather very astonishing that the women members on the on the IC at times question the intent of the complainant. Why did you go out so late? What was your need to go out to drink with him? Who asked you to do this? So it's, see, we are evolving as a society. Today, even if you see what the workforce, it's 1 against every 20 men, even in civil services. I was just reading an article. It is for every 20 men, there is 1 female IAS officer who gets elected. So we are evolving as a society. So this, the frame of mind or the perspective of people is also undergoing a change, but it will only change in a particular way if these kind of initiatives are done. If we switch back 25 years ago, perhaps we wouldn't have half of the women were working, but today we have, and it's part of a normal, accepted social status, at least in metropolitan cities like Mumbai, that a girl is working, so it is not something odd, oh, you work.
Okay.
So maybe 20 years down the line, it will be even better. But after 20 years, so that there is a very comfortable work environment for women. And many times we as men also don't realize. We may have as they call it how do they call it, a washroom talk. And we may be chatting about certain jokes or certain kind of instances without realizing that there is a female sitting somewhere who may be getting. So it is not my intention to.
Exactly.
But the impact is that.
Okay.
So such incidents are also complained of.
Okay.
Or like I said, now if there is a team, many times the manager would ask only the boys. Of course, again, that is not part of the sexual harassment, but he would ask only the boys to go out for a drink, not the girl. Now, certain girls feel offended. At the same time, if you ask, they feel offended also.
So it's either way.
Either way, but it's more often for the correct reasons that the complaints come than for the wrong reasons. Yes, one thing I would say that needs a correction or that needs to be improved is female employees don't really identify whether I am a victim of discrimination or sexual harassment.
Okay.
Like I said, they very often would misconstrue victimization in something else as a sexual harassment.
Okay.
So what a female employee would pursue is any adverse behavior against her is sexual harassment. It is not that. Like I said, asking somebody to sit late hours is not sexual harassment. Yes, it could be discrimination or something else. But that understanding needs to come instead. It will come over a period of time.
Now, sir, you are in this field and you are working on this field for 9 years. How would you compare this POSH Act of our country with, because you had been contributed to the even bill. So in that time you must have seen the laws. So how do you feel comparatively how good, proper, or need to know something about
Correct.
it.
So to answer that, this aspect of workplace harassment was for the very first time identified under the CEDAW, that is of Convention of Elimination of Discrimination Against Women. That was by the United Nations Assembly as long as 1979.
Okay.
20 years thereafter, somewhere around I think 1996, I think the Vishaka guidelines came in. And almost 20 years after that, this act has come. So there was a journey of forget implementation, even identifying that this is a problem in India, whereas in the Western world it was identified as long back as in 79. We took good 40-50 years to identify. Secondly, the participation of women is far higher in the Western countries as compared to India. It's changing. The dynamics are changing for the positive, but it's been there predominantly because I don't know. It's been a work culture like that. So that contribution has been there far more than in India. So these instances and incidents. So the law is far more evolved over there. Like there are many judgments which have gone into the root, whether it is the intention or whether it is the impact that has to be considered, which I think a few judgments in India do consider, but not many. So if there is something unique that comes as part of your inquiry, then I would first look at foreign law than looking at Indian law, because again there are, the more the participation, the more the incidents. That being said, I'm not saying that those societies are better to work for women. It's as bad or as good as here. In fact, I would say it's far better over here compared to there. So, but because I've never worked abroad, so I'm not in a position to actually tell you that. But yes, I think that it's the law is evolved more over there.
I would ask you one question, sir, that now what this law is evolving. Now, how do you see the future of this law in the coming time, and the role a practicing advocate would play in the growth of this particular act as a whatever, maybe as a consultant, maybe as an external member, maybe as a the trainer.
Right.
What you see the role of?
Well, I think I shouldn't call it scope, but I think there are immense opportunities which are in the pipeline, because like I said before, the implementation has not been so much. There has been no check. So it is only those organizations or companies who have been proactive in implementing the requirements under the Act. But nobody has yet taken stock of how many companies who are supposed to do it have actually done it. And the moment that starts happening, I think it's going to be huge, because then all the companies are going to start looking for lawyers or people who can help them properly facilitate the implementation of the requirement, do the trainings, be part of that. So I think there are humongous possibilities. There are really good field of law if one chooses to. How one should develop that is obviously have a good online presence, because in my experience it is generally the people from HR who are expected in a company to comply with this. It's either HR or admin, or if there is an internal legal team, then that legal team.
Okay.
Many times if there is an internal legal team, then they within the organization itself do the trainings and those aspects. Maybe then only the empanelment part remains. But if it's HR, like any of us would do, once my manager asks me something, first thing I would do is Google. So if you have a good online presence, which unfortunately I don't, but if you do that, then there is, or you see, attend networking events where there are HR representatives, and develop a connect, and that's how one would be able to grow.
This show actually, what you have said actually shows that there is a great potential.
Yes,
there is a great potential.
Yes.
Because I think sometime, somewhere, this will be made more mandatory and there will be more checks.
Correct.
The way it will evolve.
Yes.
Because as on today, as you have rightly said, we don't hear much except the big MNCs and
Correct.
all.
Correct.
There are a lot of small groups of industries, partnerships, we don't hear that. So all that is potentially
and especially, like I said, in the small scale industries, but so there is nothing, they don't even bother, forget being aware, they don't even bother to check. And that actually is the place where the implementation is really necessary. So yes, but I think it will be implemented in
Just
couple of 5 to
asking
10
you
years.
one thing. Government companies, say like for example,
LIC,
Khadi Village
it-
Board or whatever,
Correct.
all those they must be complying
Yes.
with this particular
Yes.
law.
Yes. So if the next time you visit a government company, it's generally at their entrance itself that it's put up, which is the committee for sexual harassment.
Okay.
And so to tick the box, it is there. Now I don't know how far the trainings are conducted and all
Okay.
that, but yes, it is. I mean, I would at least expect government companies to have done that.
Okay.
But in my experience, most of the government companies have done it. Yes.
Okay.
Including our courts.
They also are having the
Yes, yes. So
committees.
were you aware that there are sexual harassment committees in High Court and in Kila Court?
I have not seen
No.
that pastings anywhere.
Yes, so there are.
But they must be having.
There are, I'm telling you, yes.
Now just clarifying, you have explained it very nicely. But since this is for the common man asking question. The act is like sexual harassment of women at workplace. So is it only women or even men?
That is a very pertinent question. The Act provides only for women. Act provides only for women, but nothing precludes a company from making it gender neutral. So if there is a complaint of a man received from a man, then the same internal complaints committee can do the investigation, but that investigation or inquiry will not have the force of law under this act. That would just be another fact-finding committee doing it.
Okay.
So the law does not cover men.
Huh.
Because every place where it's called a aggrieved woman. In fact, there is a
Yeah.
definition of aggrieved woman.
Yes.
Which I would, a man by the articulation itself cannot be included as part of the aggrieved woman.
Okay.
So yeah, the law doesn't cover men, but yes, I don't think anything is there in law to prevent companies from making same principles for both men and women.
Okay. Sir, and if somebody is not happy with the decision given by the IC, does he have any scope to file appeal somewhere in some court?
Yes. So under section 17 of the Act, it provides for appeal, and in fact it is for this reason that it becomes even more sort of important to have a legally trained person on your, because when a aggrieved person goes in appeal, it could be the respondent, it could be the complainant. That appeal becomes the subject matter becomes company against that person. Because generally the appeal would be that you have not conducted the inquiry properly, there was this X piece of evidence which you should have considered, or you did not give me opportunity to be heard, or you conducted it in a very haphazard manner without following the principles. At that time, it is the company who comes into light. So if at all there is some lacunae in the manner in which the inquiry is conducted, then the company is the one who will have to bear the
Not the IC.
because the IC is
a part of
the
company.
part of the company. So the IC in itself is not some separate legal entity.
Okay.
So it is the company. But yes, so under section 17 there is a provision of appeal. What the rule says, as per the standing orders. The appeal will lie to a forum as per the standing orders. So depending on where you are, which you'll have to check what the standing orders say, and you'll have to go. I think it would mostly generally be the labor commissioner or the labor courts, industrial courts.
Nikhil sir, we are very thankful to you
Thank
that you have given us your time, a small moment of
Thank you
our-
so much. Thank you so much, and pleasure is all mine. And I wish all the young budding lawyers all the best. And thanks for the opportunity, sir.
So,
Pleasure.
thank you very much.
Thank you, sir.
Thank you, sir. Thank you.